So, very good evening and warm virtual welcome to everyone. I hope I am audible and visible to everyone. I welcome everyone in this very new session of the webinar on the topic, the journey from investigation to trial. So, let me start by saying that the session today is one of such topics which a person from legal background has to be very well versed with. And therefore, there is definitely a need to be addressed by someone who has expertise in such area. So we have here with us Mr. Soumya Mishra sir to basically throw some light on the topic, the journey from investigation to trial. Before starting the session, I would request our viewers to be very interactive so that we can turn the session extremely productive. Uh, so without taking much time, let me introduce Mr. Soumya Mishra sir. Sir is an experienced advocate within the demonstrated history of working in the legal service industry, and he is currently working as an advocate in the Honorable Orissa High Court. Sir is strong legal professional with BA LLB honors focused in law from Madhusudan Law College, after which Sir did his LLM in international business law from University of Southampton, United Kingdom. He had argued a number of matters as a late counsel in various subjects before the Honorable Supreme Court, High Court of Odisha, Lower Judiciary, both civil and criminal courts, state consumer forums, National Company Law Tribunal, Debt Recovery Law Tribunal, Odisha Real Estate Regulatory Authority, National Bill Tribunal, Kolkata Bench, Quasi-Judicial Authorities, Arbitration and Conciliation, Electricity Tribunals, and the list goes on. Sir has also argued very famous cases of the clients, namely Reliance Industries Limited, Hinduja National Power Corporation Limited, Tata Steel Limited, Vodafone, Hindustan Petroleum Limited, Khimji Jewelers, Air Odisha, Utkal Gramin Bank, East Coast Railway, and many more. If I would go on taking the names, it would take me about half an hour. So all I can say is, it is an honor for us and a privilege for viewers to have you on the board with us. And I'll be highly obliged if you could take up from now. Over to you, sir.
Thank you so much, Prem. I hope I'm audible.
Yes, sir, you are audible.
But frankly, I do not know if I deserve the recognition and the kind words that you just showered on me. But I would like to accept it because it was with so much of sincerity and so much of promise. Now, I would firstly like to express great pleasure in being invited to speak on this topic today by the Legal Interns, which I learned that is a group of very bright law students who have come together for a common purpose to sort of build a bridge among all the students from across the country in various aspects of educating each other as well as forwarding each other's objectives as a whole. Now, getting into the topic for today, which is the journey from investigation to trial. To be honest, when Mr. Prem Piyush Pandey approached me a few days ago to speak on this topic, the first question I asked him was, how much time am I given to speak on this? Because frankly, this is such an exhaustive topic and very rightly coined as well, the journey of investigation, because it is in fact a journey. And, the journey has started from 1898 when the Code of Criminal Procedure was brought into force. It came into force on the 1st of July, 1898, went through amendments in 1922 and 1955. And there was really no necessity to bring about a major revision till the Central Law Commission, which was set up in 1955, by its 41st report in the year 1969. They proposed a lot of changes which were to be brought about to the Code of Criminal Procedure of 1898. And accordingly, the 1973 code was brought into force. Now, I do not have the time to go into all the changes that were brought about by the 1973 code, but essentially a lot of aspects remained and a few additions were made in order to streamline the code in accordance with the changing requirements of the society. Now, this was a little brief history about the code because I was very tempted to address on the history of the code because of the title of the topic, the journey of investigation from trial. Now, if I was to give a lecture, I would probably just the side sections and all of that. But I understand that there are a lot of students who have participated in the webinar, for which a basic knowledge of the investigation has to be said aloud. So the common question that actually comes to all of us is what is exactly an investigation? Investigation is such a wide term having a lot of meanings attached. Thankfully, the code has defined it under section 2H of the code itself, and it covers all proceedings which are in fact conducted by the investigating agency or the officer in charge of the police station or any person, officer authorized by the magistrate in that behalf, but does not include the magistrate per se. Because the moment the magistrate is involved in the process of investigation, it is no longer an investigation, it is called an inquiry. I will get to all of those details in a bit of time. Now, the moment an information is given or produced before the officer in charge of a police station, and the same relates to commission of a cognizable offense, the officer in charge of the police station, in accordance with section 154, is required to reduce it to writing. And that is very commonly known as the first information report. Now, the term cognizable offense is very important because ideally, a police officer, even though has the right of investigating into a non-cognizable offense, but that is only upon a direction or an order made to that effect by the magistrate under section 156 subsection 3 of the code. So therefore, for now, it is very important to understand that it is only the cognizable offense that a police officer is entitled to take cognizance of and act in accordance with the process involved in the code. Now, in the event such an information which is given by the informant or the victim, as the case may be, and it is not reduced into writing in terms of section 154(1) of the code, then the informant has the right to file a substance of the said information to the superintendent of police of competent jurisdiction, and who shall act upon it and direct the police officer to do the needful. So essentially, the first thing which the officer in charge of a police station, upon receiving information offense, is to find out is that whether it is cognizable or not. If it is not a cognizable offense, then he is simply to refer the informant to the magistrate in terms of section 155 of the code. The magistrate, of course, has the power to either commit an inquiry in terms of the code or direct the officer in charge of the police station, as I just said a few moments ago. Now, and at this point of time, of course, it is very important to know what is a cognizable offense and a non-cognizable offense. For people who are well versed with the code as students of law or as lawyers or advocates practicing in different courts, they would know that a cognizable offense is by the term that it signifies an offense which can be taken cognizance of by the police or any officer authorized in that behalf and act in accordance with the code for the purpose of investigation and preparation of a final report in terms of the code and submission before the magistrate, who then takes over in accordance with the code again and performs his set of actions. A non-cognizable offense, which is mostly associated with less serious offenses, if I may say so, they are to be only taken cognizance by the magistrate as per the code. So the magistrate is to be forwarded, the informant, is to be forwarded to the magistrate in terms of section 155. And the magistrate in terms of section 155 subsection 2 can direct the police officer or the officer in charge of a police station to take cognizance of the same, register an FIR, and perform the investigation in accordance with the code. At this stage, it is very important to know that once an information has been reduced into writing and an FIR is registered, what can the police officer do? Now, the officer in charge of a police station before whom the information has been given and he has reduced it to writing, in terms of a cognizable offense, he may arrest the accused without a warrant. Now, Section 50 says that if you're arrested without a warrant, then the arrested person has to be given a memo. There's a mandate. He has to be given a memo citing all the reasons of his arrest, of the offenses he's alleged to have committed by the informant. What is the remedy available to the accused in that case? If an accused apprehending arrest, this I'm talking about prior arrest, apprehending arrest, then he can resort to an application filed apprehending arrest for release of his bail in the event he's arrested by the police. And that is filed under Section 438 of the CRPC. Insofar as an accused person who has been arrested without a warrant, in terms of the offense being a cognizable offense and the police officer in charge has taken cognizance of the offense and arrested him without a warrant, he has the right to file an application for bail under Section 439 of the code. It is very important to know at this stage that the officer in charge of a police station who arrests an accused person without a warrant on the profound belief of him having committed a cognizable offense, he is required to produce him before a magistrate within a period of 24 hours in the event he is of the opinion that the investigation will not be completed within that period of time. And then the court, obviously, I will not go into the details of that, but the court has its own procedure to be followed. The accused can be sent to custody of the nature the magistrate thinks like. So this is the rights of the accused in terms of the code. Now, what happens when the informant or the victim's information is not reduced to writing by the officer in charge of a police station? Now, what happens very often is a common citizen, a common man who does not have much knowledge of the law on point, he anyway goes to the police station for lodging of an FIR without having regard to the fact that if the offense is cognizable or non-cognizable. Therefore, the code has envisaged a provision wherein it has empowered the officer in charge of a police station to forward the informant to the magistrate in terms of Section 155 of the code. So there, so if an informant approaches an officer in charge of a police station and the officer in charge does not register such information into writing in terms of Section 154 or does not forward the informant to the magistrate in accordance with law, there the informant has the right under Section 154 subsection 3 of the code to approach the superintendent of police, which I said in a nutshell just moments ago. There again, if the informant is not given what is due, in as much as no information has been reduced of his to writing and no FIR has been lodged by the competent authority, then he may move the magistrate for registration of a complaint. And the magistrate, in exercise of either 156(3) of the code, direct the police officer to do the needful. And in terms of a non-cognizable offense, the magistrate may proceed again in terms of Section 190, which empowers the magistrate to act upon a complaint, or directs the police officer again to register the FIR in terms of 154. So there you have the rights of the accused as well as the victim in terms of the inaction, so-called inaction of the authorities in question. There have been numerous cases filed in the Orissa High Court, and to be honest, I am part of it as well, where the FIR is not registered by a competent police officer, where in the local limits of which the offense has taken place, alleged offense has taken place. We moved the Honorable High Court by way of filing a criminal miscellaneous petition alleging inaction of the police. Very correctly, and I bow down to the observations of the honorable judges of the Orissa High Court, what they do is that they dispose it off, by order, saying that you approach the SP, because the code has express provision in cases where your FIR or your information is not reduced to writing. So this is a practical aspect of the provisions which we face in daily lives. Now, going over to a situation where the officer in charge of a police station has acted with prudence, has reduced the information given by the informant or the victim into writing in terms of Section 154. It is a cognizable offense. And so what does he do next? Among the several procedures that he has to follow, there are a plethora of provisions relating to the process which is to be followed by either a police officer or the investigating officer or the investigating agency, as the case may be. So I would not go into those exhaustive discussions of those provisions, as it would kill a lot of time, and we are under a time restraint, of course. One of the most important things that the police officer does or the investigating officer does is act in accordance with Section 161 of the Code, where it has the power to examine witnesses or such persons who are acquainted with the facts of the case. Of course, 161 clearly specifies that a person who is examined as a witness on the pretext of being acquainted with the facts of the case is not required to disclose such information that would eventually arraign him as one of the accused in the case. That liberty has been given to the witnesses in order to protect the sanctity of the provision insofar as the process of fair investigation is concerned. A fair trial obviously begins with fair investigation and a proper investigation. So therefore, such provisions have been embedded or embodied in the statute so as to clarify any negative air about a witness going in and being examined by the police. I will obviously go into the admissibility of such evidence from such witnesses under Section 161 at a later time. Then comes the examination of the accused, which we often call as the confession of the accused, confessional statement. Now, the accused is obviously given a scope to confess his crime. And his statement is also recorded by a magistrate who has or doesn't have jurisdiction. Because such recording of the evidence or the confession, so to speak, is also used for a certain purpose, which I will come to at a later time. There are subsequent provisions which deal with the police officer or the investigating officer having the power to summon persons, to search persons, to take the assistance of an officer in charge of another police station within whose local limits a corresponding crime might have been committed, or a chain of circumstantial evidence might be formed. So the police the investigating officer or the officer in charge of a police station or the investigating agency, as the case may be, they have a full-blown process that is to be followed, which is outlined step by step in the code, and it is for all of you to just go through it. I will now go over to that point where an accused can be discharged by the police officer, investigating officer, XYZ, whoever is been given the authority, if upon committing an investigation it is found that there are not enough or no incriminating materials against such accused person. Of course, such discharge under Section 169 of the Code is subject to what the magistrate thinks. So it is discharged upon surety of bond, which the accused is informed that he may be called upon by the magistrate upon submission of the final report. Now, discharging of the accused under 169 is also required to be written in the form of a report. Now, that report is submitted to the magistrate in the form of a final report, which is also done under 173(2) of the Code. So therefore, it is settled now that even if the final report of discharge, the final report of coming to a finding by the investigating officer that the accused has to be tried by the magistrate, it is the magistrate who is to decide whether he is to take cognizance of the offense or not. It is not mandatory that if the police officer or the investigating officer or any other officer authorized in that behalf has come to a conclusion in the report that this person, the accused, has to be tried and cognizance has to be taken, the magistrate is not bound to do so. Magistrate will act upon his individual powers under the court and come to a conclusion whether he's to take cognizance of the offences that have been laid down in the final report by the police. Now coming to 173 itself. Before coming to 173, it's a very common question that I keep getting from my learned friends in the law colleges, that what is a closure report? A closure report is this. Closure report is section 169, the report prepared by the investigating officer discharging the accused, subject to what the magistrate thinks about it. Now, 173 is what we call the submission of a charge sheet. It's a final form which is submitted by the police upon completion of all investigation. Now, 173 is a provision, obviously, which was also in place in the 1898 code, with the exception of subsection 8 of 173, which says that there is a power given to the investigating officer for further investigation after submitting the report, final report. If such materials come to light, which would then lead to a probability of the accused person, one of the accused persons, not being, not deserving enough to be in the list, or someone else who has been left out. So to do complete justice to the informant and the victim in more grievous offences, this provision was incorporated, and this provision was incorporated upon the recommendation of the Law Commission in the 41st report, as I said in the beginning, while narrating the history of the code. So 173.8 incorporation is one of the major changes in the 1973 code, if I may add. Now, thereafter, before moving on to the duties cast on the magistrate upon submission of the final report, I came across a very interesting case, which my friend passed it on to me when she heard that I was invited to speak on this topic today. This is by the Honorable Supreme Court in the year 2019. Now, the law was settled with respect to the fact that once the final report has been submitted and the magistrate has taken cognizance of the same by virtue of section 190 of the code, 173.8 cannot be resorted to by the magistrate, which is further investigation or a direction to the investigating agency to commit further investigation upon receiving such information that he might think that, all right, there is a requirement of further investigation. The reason for that law was that 156 subsection 3 essentially authorizes or empowers a magistrate to direct the officer in charge of a police station to commit an investigation in the manner provided in the code. Now, that provision which is embodied in the code is a pre-cognizance, so to speak, provision. And once the cognizance has been taken of the offences as per the final report, the stage of the investigation is post-cognizance. So the code is silent on the magistrate having the power to relegate the scene to pre-cognizance stage. But here, Mr. Honorable Justice Nariman, he came up with a very interesting observation. He has held in the judgment that with reference to the definition of investigation under section 2H of the code, which includes all proceedings under the code, the magistrate can order for further investigation in terms of 173.8 of the code, in exercise of the powers under section 156.3 of the code, because if the trial has not commenced. He has further gone on to say that when the trial has commenced, it would mean that the charges have been framed. So there, if the magistrate is of the opinion that any fresh information that might have come in relation to the case, there the magistrate can direct for a registration of a fresh FIR in terms of 156(3), and then that can be gone into investigation by the police officer or the investigating officer. And any application to that effect, an application to the effect that to stay the existing trial may be entertained by the magistrate, subject to whether he wants both the offences committed or the sets of offences committed in a joint trial or a trial held simultaneously, one after the other. So you see, I wanted to give you the practical side to the provisions relating to investigation. The reason being, we keep arguing in the courts that the law is settled, but the law is not settled. Let me tell you, this 2019 judgment of the Honorable Supreme Court has upset a lot of judgments, and they date back to 30 years back. So therefore, the interpretation of the statute is always open for debate. Anyway, I just wanted to project that view because since I read that interesting judgment yesterday. Now, moving on to the process, with what happens in the event the magistrate is convinced with the final report, is convinced with the investigating materials presented before him. Now, 173 has a list of things that the final report is to contain. So, subject to the fact that the magistrate is convinced to act in accordance with section 190 of the code, there the magistrate will have a separate set of functions to attend to. Before I address on the procedure of inquiry, not investigation, inquiry that the magistrate is to conduct, I must indicate that section 190 of the code has 3 types of cases which the magistrate can take cognizance. One is a complaint, a private complaint, which does not include a police report. When does a police report become a complaint? That is very interesting so far as the practical side of things is concerned. When does a police report prepared under section 173(2) become a complaint or can be treated as a complaint? Because a police report is a report. It can't be treated as a complaint like in the manner provided under section 156 of the code. Where under section 156(3) of the code, the magistrate directs the police officer to act in accordance with the process involved in the court to investigate upon an offense committed, cognizable, non-cognizable, and the investigating officer or the police officer or the officer in charge, whoever may be, files a report under section 173(2). That forms a complaint for the purposes of the magistrate to take cognizance of the said offense under section 191(b), not 1A. A is private complaints. There is also 191(c), which speaks of information given to the magistrate upon which he can also take cognizance of offenses. That is obviously very rare. A and B are obviously much more in practice. Once the magistrate takes cognizance of the offenses, it is his duty to examine the complainant, because all of you know the basic tenet of criminal law in India is, and has been all the time, is that the person accused of having committed an offense is presumed to be innocent until proven guilty. So therefore, the burden of proof of proving the offense lies in the prosecution. And therefore, the provision ordains in the code, so far as examination of complainant is concerned. Why such a provision has been ordained in the code is, once you examine the complainant and the petition for the complaint, there the magistrate can come to an opinion whether the complaint is to be dismissed or he is to proceed with the remaining aspects of inquiry in order to get into trial. If it is dismissed, then obviously end of the matter. If he proceeds, then obviously he will issue process on the accused. And there are a lot of aspects with respect to issue of process to the accused. If he's outside the territorial jurisdiction, then he needs to postpone the issue of process till further satisfaction of the offenses he might have committed and all of that. I will not go into that because it will again take a long time. Now, once the magistrate is convinced that the offense which he has taken cognizance of is a tribal offense by the magistrate and not by the Court of Sessions, he shall start with the evidence. Now, evidences are of few types, and they could be oral evidence, which has to be direct, documentary evidence, there is primary evidence, there is secondary evidence, and a lot of subcategories of secondary evidence is like electronic evidence and so on and so forth. The basic thing that is to be understood here is that the accused is not examined per se. There is no defense of the accused. A statement of the accused is taken. If you remember, I had referred to section 164, which is the confessional statement of before a magistrate of an accused. Now, that statement which is recorded under section 164, that statement is for purpose of reference, for the purpose of corroborating the statement of the accused, which is in fact taken or recorded under section 313 of the CRPC. So there, it is for the facilitation of the magistrate to come to a finding, so to speak, on the commission of the offense or not. Now, prior to trial, there is a procedure which is followed by the magistrate in order to frame charges. There is a hearing which is done. The prosecution is obviously represented by the public prosecutor or any government advocate that the state might have appointed in that behalf. There are provisions to that effect. And there is a hearing on the charge, there is a framing of charge, and so on and so forth. Once all of that is over and the recording of the evidence of the prosecution, the statement of the accused, the defense of the accused, all of that is done, then the magistrate obviously goes on to pronounce judgment and essentially keeps the matter to a short date for the hearing of the sentence, so to speak. Now here, prior to all of this, the investigation, the hearing of the trial and all of that, there is a very important remedy that is available to the accused. Now, you might have heard on numerous occasions that there are false cases. We read numerous cases that have been filed against people with absolutely no basis, and the trial is dragged on for years, and there is a lot of mental harassment, torture. There is a media trial, so to speak. We are facing all of that on social media these days. So there is a very important remedy available to the accused or the person alleged to have committed the offense, and that is to move the Honorable High Court having competent judicature under section 482 of the CRPC. Now, what does 482 say is, it is the inherent power of the High Court. So there are several judgments on this. Under what circumstances can you move the High Court in exercise of its inherent jurisdiction? The remedy per se is to quash such a complaint, or to quash such an FIR, or to quash an order of cognizance. If on a bare reading of the information or the complaint, or as the case may be, it is found that there is no offense which is made out. Sometimes on a bare reading of the complaint or on a bare reading of the information, you come to as a student, also as a law student, even I have come across a lot of materials during my studentship, where I would just logically come to a conclusion that this doesn't form any basis for registration. So there, the High Court in terms of the judgment of the Honorable Supreme Court, has the power to exercise its inherent jurisdiction to quash an FIR in toto, or to quash a complaint in part, or an order taking cognizance of the offences. So this power, although is used very sparingly by the High Court, and upon satisfaction of certain guidelines which have been laid by the Honorable Supreme Court from time to time, there the accused has a very important and crucial remedy available to him. So this is something I wanted to also add in, because this is such an exhaustive topic that some things which I might have missed out in chronology, I might be saying, adding them right in the end or right in the middle somewhere. But this is very important for all of you to know, students especially. Once you come to the bar and practice criminal law among other laws, it is very important to know what is the remedy available to your client. And it is very important for a practicing advocate or a lawyer who is advising clients to be able to figure on a bare reading of a complaint or an order taking cognizance whether the legal aspects have been followed, the mandates have been followed by the competent authority. Now, before I've obviously told you about the how a trial is held in very summary manner, but it is very important to know the kinds of trial available as well. Now, the most common trial that you might have heard of, or the important case laws that you might have read about, they're all warrant trials. They're all warrant trial cases. What happens is, sometimes when an information is sought to be filed before the officer in charge by an informant, it involves a non-cognizable offense. And what happens is that the police officer has no right to take cognizance of the matter. So he seeks for the direction of the magistrate to issue a warrant or summons, as the case may be, in favor of the accused, because he will essentially not have any right to take cognizance and to arrest. Also, depending upon the nature of the case, as mentioned in Schedule 1 of the code, you would also know whether it is a trial, it is a warrants case, a warrants trial, or a summons trial. Essentially, warrants trial are for graver offences, more than 2 years imprisonment, death, and all that. The most the shortest form of trial, which lasts for a hearing or two, is the summary trial, which is for very petty offences compared to the other offences. No offence is petty, but obviously comparing to other offences, petty offences. So these are also the different kinds of trials that we get to see on an everyday basis. So on the whole, if you look at it, the journey from an investigation to trial covers the entire procedure. If it's a cognizable offense, it has to go through registration of an FIR, arrest of the accused, production of the accused before the magistrate within 24 hours for appropriate orders to be passed in that behalf. You have permission of the magistrate to commit a preliminary inquiry, statement of the witnesses to be examined, confessional statement of the accused is to be recorded, which is to be corroborated by the statement of the accused during trial under Section 313. Then you have the option available to the police officers or the investigating officers to search a place, search a person, take the assistance of another officer in charge of another police station who might have better knowledge of the happenings of the offences that he's investigating upon. Then you have the power of the police officer or the investigating officer to discharge the accused in terms of 169, and the final report under Section 173(2), of course. And then the magistrate has the option of taking cognizance of that order. Once he takes cognizance of that order, it is open to the victim, the accused, to seek for quashing of that order of cognizance. Such order of cognizance is also quashed in full or in part, as the case may be, by the High Court in exercise of its inherent jurisdiction. and the different types of trials we have, the different types of evidences we have. I think uh, this will take ages to sort of address. But I only wanted to provide a basic knowledge about the journey, so-called journey, as well as the practical difficulties and the remedies which are available but are sometimes overlooked by lawyers inadvertently because of lack of awareness of what is available to them under the code. And there are a lot of things like Section 50. If you're arrested without a warrant, you are to hand over a memo to the arrested person stating the reason of his arrest. So a lot of these things are not made known to the persons by the authorities, by the officials, which results in a not so fair trial. And a lot of times, speedy trial in the quest for expeditious disposal or expeditious trials, the fair trial concept is ignored or overlooked. So the concept of the court was never to overlook the concept of the aspect of fair trial. Fair trial has been a part of this court since 1898, believe it or not. And I cannot go into the details of the amendments that have taken place in 1922 and the 1955 because I have lack of materials regarding that. But I can tell you that there has been constant amendments to the 1898 code, as well as there was a need to repeal that 1898 code and enact a 73 code so as to meet the changing demands, the changing scenario of the law in the country and the society at large. So the concept of fair trial cannot be overlooked, and it is the duty of advocates, duty of lawyers to understand what is the scope of remedy available to the clients or to an accused, to a victim, to an informant. So it is very important to have a thorough knowledge on the code. Thankfully, as lawyers, we will be able to rely upon the books or the bare acts while you're arguing a matter, because at the end of the day, what you essentially need to ensure is that your client gets the benefit of the law of something which he has not committed. So if there are any questions relating to any anomalies that you might have found during the the talk that I've had today, you're free to ask. I think I've covered the basic aspects. If someone wants to figure out something in excess to what I've said, you're always free to ask, I guess. Mr. Prem Piyush, if you can coordinate, please. Am I audible, Mr. Prem Piyush?
Yes, sir. Yes. So just a second.
Sure.
So I hope this brings us to the end of the webinar. A huge thanks to Mr. Soumya Mishra, sir, for being with us. It was really a privilege having you, sir. I hope you are taking. I hope everyone is taking something out of it while turning off the screen. It was a privilege having you, sir. So if anyone needs any advice, any question, any suggestion, you can reach him by mail ID, that is soumya.misra@live.com. I repeat, soumya.misra@live.com. He is always happy to help young lawyers, students, and legal fraternity. At last but not least, I would like to thank all the participants who had been with us for the webinar. Thank you all and wishing you all the very best. Thank you, sir. Thank you, sir, for having me.
Thank you so much. Thank you. Thank you so much.